Police Court. On appeal, what the defendant raised for the first time was that it was a due process violation for the sentencing court to consider and rely on the Iowa Risk Revised Assessment as part of its sentencing decision without the disclosure of cautions and limitations.
Say on appeal it was raised the first time. How was the defendant supposed to raise the issue in the court below before the court told the defendant what the defendant was going to use to sentence him?
It goes back to the error preservation issue that the Court of Appeals bypassed. If the defendant wants to make a due process objection to an item in the pre-sentence investigation report, we believe it's his duty to raise it at the time of sentencing. The defense has the PSI in their hands a week or 2 weeks prior to the sentencing date, so it can look it over, see if there's anything in there they disagree with, and then they voice that.
Statute requires 3 days before sentencing. Do you know that this was more than 3 days?
I believe it was more than 3 days, but it was at least 3 days. And the defendant was asked about any objections at sentencing and only voiced a minor objection.
As I read the PSI, you're probably not familiar with the case argued before you, though you were sitting here. In this PSI, there is nothing explaining what that risk assessment tool was and how it was administered. I think it had who administered it. But, you know, how's the defendant going to do it when there's one sentence in there that says he or she is a high risk for offending?
Again, they can either object at sentencing or raise an ineffective assistance claim later and say, you know, counsel should have objected to the risk assessment being in the PSI for whatever reason.
Is the state's position in this case that this is an ineffective assistance claim and the record's not sufficient to decide it? Or it's an ineffective assistance claim and the record is sufficient to decide it?
I think if you want to get into the nitty-gritty of what are the underlying factors in the Iowa risk assessment, how have they been validated and when, what's the scoring methodology and weights that they use, I think if you want to get into those things, they have to be raised in the district court, if not raised on appeal as an ineffective assistance claim.
My question, that's not the answer to my question. My question is, can we decide the ineffective assistance claim on this direct appeal, or do we have to wait until the record is fully developed?
We believe waiting for a full development of the record would be appropriate. All of the additional articles, research papers, and commentaries cited by the defense in this case, we don't think should just be accepted as scientific evidence in the way it is, because the state had no opportunity to make a corresponding record below.
So in every sentencing case, it's a question of fact, and in every sentencing case, the defendant can challenge the validity of whatever actuarial studies are included, and in every case, you can develop your own expert testimony, kind of like a medical malpractice case. I mean, you know, when an expert testifies, you go out and get your countervailing experts. So in every case involving these studies, the defendant would be entitled to an expert presentation challenging the validity of the studies.
That's correct. In SVP cases, there's a complete record made with an expert, and I believe in those cases the jury is told about the particulars of the particular test being used.
The one Court of Appeals case, there was in fact a Dauber type challenge in an SVP context, but most of the cases don't have a Dauber type challenge. I mean, you know, kind of challenging the validity of the underlying tool. In fact, even in the Holtz case, that wasn't the challenge. The challenge was to the expert testimony. But I guess the bottom line is, I am concerned about the record. Okay, I mean, I'll just say it. I'm not exactly sure what the procedural, you know, complications are, but In the ideal world, I'd like to see a fully developed record before figuring out, you know, whether it is pertinent or relevant, and whether it ought to be considered. What I hear your position is, basically, we're going to have to litigate it every time in every PCR whenever a defendant wants to raise the issue and go to the court and get payment for an expert. And if you don't get payment for an expert, that'd be a problem. So I invite you to respond.
I don't know that you do it in every case. I don't know how many risk assessment tests are at issue here. The Board of Parole has their own risk assessment test. The two tests at issue in the Gordon case are sex offender-related tests. In this case, we have the Iowa Risk Revised Assessment, and if we were allowed to make a record on that, I think you would find that the factors are pretty simple, and they really are the factors that are listed in section 901.3 and routinely detailed in narrative fashion in the PSI. In this case, the PSI investigator said as part of the interview with the defendant, an Iowa Risk Revised Assessment was done, and then came up with the suggestion that he needed intense supervision. I think the defendant must have been told about that, because when he asked what he needed, his response was he needed intensive probation and drug treatment. So he seemed to be aware of that, and no objection was raised. We believe the Court of Appeals majority was wrong in not using error preservation to decide this case, when this court has consistently since 1968 held that unchallenged information and statements in a pre-sentence investigation report may be considered in determining sentence.
Well, that's generally right, but here's what bothers me about the PSI, and that is it's used for many purposes. Well, at least two purposes, actually. One is by the sentencing judge, of course, routinely, but it's also used by DOC routinely. The PSI doesn't disappear after sentencing. It doesn't go and be gone. The PSI is relied upon by the Department of Corrections in its management of inmates. So you had the benefit of the earlier argument, but we have the footnote there saying, well, it was hard to anticipate that these studies would be used because they're designed really for management of inmates and not so much for sentencing, and that excused.
I don't think we know that for sure from our incomplete record. I don't think we know exactly what populations the IRR has been validated on.
Do we know from the record what the purpose of the Iowa risk assessment?
It is to determine the risk of violence and victimization, as well as general recidivism.
Is there any problem with the court not following section 9014 about PSIs presented? If someone wants one of these mental health reports, which or extra reports you relied on, you have to request it, which wasn't done in this case because it's not included here. And then in order for the defendant to, have a problem with it, they have to file a written objection or refutation of information contained in the PSI. I mean, do district courts routinely disregard the requirements of 9014? Because I've never, I see routinely that they say, do you have any objection to it? But that's not the procedure under the code.
I guess I haven't seen a lot of judges following a particular procedure. I think they usually leave it up to the defendants or defense counsel to question a statement of fact or some evaluation or report that's contained in the PSI.
Just because there's a requirement for 3 days beforehand, do you find it reasonable that the court might just still ask on the day of sentencing any objection, and if nothing's been filed, then that statute's been complied with, and even if on the day of sentencing the defendant maybe had an objection? Have you had that situation arise where there is a last-minute objection? Have you had any of those come to your attention?
Really, the only objections that we typically see are the ones that say, you have an arrest listed, but the defendant wasn't convicted on that charge, so it shouldn't be considered, or
Usually just corrections, perhaps, and not so much objections.
I've not seen any defendant object to the mental health or substance abuse evaluations, and sometimes those are attached to the PSI.
And have you also seen them where the defendant refused to participate in portions of the PSI?
Yes.
Could the district court, if we remand for resentencing, could the court impose the same sentence?
I think the court would, because if you take a look at the PSI, every undisputed fact supports defendant's statement that he needs intensive probation and drug treatment. The PSI listed a long list of his needs, a lengthy criminal record, numerous revocations, drug abuse, and he was only out on parole 1 month before committing this offense against the same victim that he was on parole for domestic abuse. He also violated a no-contact order after his initial arrest and incurred an additional charge involving violence against an officer. He clearly was not a good candidate for probation.
Yeah, but our sentencing cases say that even if it's a secondary consideration, we don't fuss with all this stuff. We send it back. So, and the district court also very clearly stated that it was because of the IRR. For that reason, I'm not accepting the plea agreement.
I think if you read the record carefully, the court lays out a whole bunch of other reasons prior to that.
It does, but then says for that reason, and is referring to the study.
I think that needs to be viewed in context. Because it's always improper for the court to rely on a single factor in sentencing or an unconstitutional factor, but this court and the court in Gordon as well clearly relied on all of the information in the PSI, of which none of it was objected to. On the due process issue, the state would point out that first, as the Court of Appeals dissent did, due process places few limitations on the categories of information that may be considered in sentencing. Second, the defendant had an opportunity to object or challenge facts in conclusion. He did not ask for a validation study, a list of factors, the scoring methodology, or even request that an expert or DOC person be present to testify about the assessment. And the district court is not bound by any assessment or by the PSI's sentencing recommendation. And finally, the two cases the defendant relies on do not support his argument. Neither Loomis nor Malinchuk did they find a due process violation. The Iowa Risk Revised is a different type of test. It's non-proprietary. And because of our indeterminate sentencing scheme, our courts are not determining the length and severity of sentence, only the decision of whether or not to grant some form of probation or incarcerate the person. We believe offenders' risk to reoffend and his or her amenability to supervision in the community is directly relevant to the court's decision between probation and incarceration. And I think down the road, it will be shown that an actuarial risk assessment provides objective, evidence-based information that supports both considerations, providing information on the levels of sanctions, programs, and services available.
Yeah, we just don't know that. I mean, we just don't know that. I mean, what we know is what the record reveals, and that is that this IRR was considered. The record itself, I mean, I know you're referring to some other documents, but the record itself doesn't tell us much about the IRR. We know that a conclusion was drawn about intense supervision, and we know that the district court relied on that conclusion. That's about all we know in the record.
And that's why a complete record needs to be made for these kind of challenges. In fact, in at least 3 counties, defense attorneys have raised the issue relying on the Gordon and Guise Court of Appeals decisions, and it has resulted in contentious sentencing hearings and some continuances to revise PSIs, take the information
Anything wrong with
out.
that? I mean, contentious sentencing hearing, I mean, I thought we had an adversary system. I mean, there's nothing wrong with a full-blown attack on these in the context of sentencing, or am I missing something? Are we so concerned about efficiency that we're not going to allow the defendants to hire experts and so forth?
No, the state would encourage the issues to be raised in the district court, and I'm not sure we need to do it in every single test, in every single case. I mean, once you have a court deciding on the merits of the IRR versus static 99 and whatever else they might challenge, I don't think down the road it would go smoother. The state would ask the court to reverse the Court of Appeals and affirm the defendant's sentence. Thank you.
Ms. Hall, thank you as well. Ms. Nye?
Good morning. May it please the court. My name is Melinda Nye, and I represent Mr. Montez Guise in his appeal. Sort of know the fact or the procedural background, but he pled guilty pursuant to a plea agreement in which the state recommended a suspended sentence. A PSI was prepared which included a single reference that as part of the PSI interview process, an Iowa Risk Revised was completed indicating that Mr. Guise should be supervised at an intensive level.
Can I ask you a question? You
Yes,
know,
please.
he didn't object to the PSI.
Right.
He said you could consider it. What's the air preservation? And is this can we do it on direct appeal, or is this really an ineffective assistance of counsel claim that his counsel did not object to it?
I think this can be decided on direct appeal. As sort of been alluded to, this is like an improper factor. I think so. You know, there's several cases out there that talk about information that's not objected to in the PSI is fair game for consideration by the district court. But those.
How do we know it's an improper factor? We don't even know what it is. There's one sentence in there. I mean, it may be a proper factor, as mentioned by some of my colleagues. Society and all the major ABA, ALI, Chief Justice's Council, they're all moving towards risk assessment. And if it's a valid risk assessment, it may be a proper factor, but we don't even know how you get to the darn thing and who did it and under what circumstances. I mean, so how can we say it's an improper factor when you don't make the claim and you don't bring the information to us, which is your duty at this point?
Well, that's sort of, there's two pieces to that. That first of all, the way it was included in the PSI, as far as having a duty and no, I mean, the way it's included in the PSI, there's not a reason for the defense counsel to know and expect that the district court's going to take that one-liner and use that as the hook, that this is why I'm not accepting the plea agreement, this is why I'm sentencing you to prison.
But if you said, if it was in the PSI that he killed 16 people, which was completely false, you know the defense attorney's going to say he didn't kill 16 people and it's totally false.
Exactly.
If there's one sentence in there that makes no sense because you don't know what it is, don't you think the defense attorney has an obligation to talk to the court about it or alert the court to it?
Not necessarily. I don't think so, because I don't think it's not that it doesn't make any sense. We don't know what, there's not information in the PSI about the IRR, how it's calculated and scored and what its validity, et cetera. But it's in there, the PSI serves several purposes, including DOC planning, and the way that it's incorporated into the PSI, that it's recommending him for intensive supervision, it sounds like that's what it's meant for, that this is about DOC planning, not sentencing court consideration. And so
The objection, the requirement of a contemporaneous objection to content in the PSI report depends on whether you can reasonably expect a sentencing judge to use the asserted fact in sentencing?
yeah, I think that's part of it. Just, as in the Court of Appeals noted race, there's lots and lots of information in the PSI that could be used inappropriately by the district court, that you don't have to object that your race is in there if it's a true fact that your race is what it is. In this case, he's not objecting that DOC wants one.
Race is an objective fact. You're black, you're white, you're green, you're purple, you're pink, whatever it is. A risk factor that you're highly likely to reoffend is not an objective fact. It's based on something. It's based on some kind of test or some kind of intuition, or maybe it's based on some speculation. We don't know. And I think it's different than that.
I think that if he disagreed that he should be, you know, that he, yes, he took this test, he participated, they conducted this assessment, that's a fact, that's true. He scored what he scored based on, I mean, the PSI interviewer scored him where he scored him. If he disagreed with that and wanted to challenge the results that it was scored improperly, or that, you know, that somehow that, you know, he shouldn't have fallen into the high-risk category, or shouldn't be supervised intensely, that he should be subject to a lower supervision level. If he disagreed with that, the sort of the result, then that's where the full-blown hearing, and you bring someone in and you contest those underlying facts. But the fact was, he was assessed. This is what DOC, how they scored him.
Well, let me ask you this question. If the IRR was not part of the pre-sentence investigation report, and the trial judge otherwise goes through the report, considers the evidence, talks about his age and his employment and how he's done on prior supervisions, his prior record, goes through all of his histories, and he says, or she says, you know, I think you're a risk to reoffend based on everything I've looked at, and I'm going to sentence you to prison because of that. Would you be before the court saying the judge can't do that because everything that the judge considered doesn't add up to the conclusion that the judge reached? Would you have any appeal there?
I think that's the court, that's absolutely one of the considerations the court makes.
Okay, so sentencing is very, very discretionary.
Yes.
You can have the same defendant brought before 100 judges, and they'd probably get one sentence and half would give another sentence.
I'm having a
Risk assessment is here to make it a little more precise, a little more exact, give a little greater assessment, a little help to the judge. Why are we complaining about the inappropriateness of giving judges a little more teeth to make a decision with?
I think that the factors that go, let me make sure I get this right. The judge does consider all of those things, and you know, the idea of having more information and more, you know, having something that's more reliable and can take away, you know, I think that is an important aspect. The problem is that the district court doesn't know. So the district court says, I'm considering your age and your background and your other offenses, and the judge is weighing those, and how the judge exercises his or her discretion in reaching a just sentence based on all of those considerations is the judge's job.
But we're dealing with risk assessments by professionals that work with these probationers and parolees, and the facts and the statistics that are derived from that. Wouldn't that, in a large sense, be of value to a sentencing court to have the benefit of that perspective and their experiences in supervising probationers and parolees?
I think that if the court determines it could, you know, it can be important and relevant. The problem is that the district court doesn't know how it's been calculated, what factors are taken into account. And so what happens, you know, especially sort of we see it in this case, you know, Iowa Risk Revised, we've been able to sort of glean from, you know, handouts and agenda meeting notes that it takes into account age, it takes into account criminal history, prior revocations. So now we've got, you know, getting someone who's getting sort of double dinged for these same factors that.
Well, by very nature, if the state is going to get more precise with a judge, isn't the defendant going to have to come back at the sentencing hearing and be equally more precise and attack the basis for this more precise information? I mean,
I'm sorry, repeat that.
Well, if the state is going to load up the PSI with the evidence-based science, if the defendant doesn't believe in it, isn't the defendant going to have to come in and challenge it at the hearing, just like we do in all other court proceedings?
You know, I think what we've asked for the court to do at a minimum is require that the court be advised through the PSI, you know, of the limitations of the you know, the factors that are used to to create these, so that we don't have to have full-blown hearings every time. If someone wants to dispute that they fall as a high risk, that would require.
Well, are we gonna have to let it run its course? There's gonna have to be a couple years of the defendants challenging the state's use of risk assessment, and then we'll sort it all out, and then go with wherever we end up.
I think I do think that this will not be the last word on the subject, just because risk assessments change. There are various risk assessments out there.
That's what I want to talk to you about,
Yeah.
What's included in the PSI. It's as if this is the only thing. PSI is chock full of all kinds of stuff. They go out, they'll talk to people. Are you saying that the judge needs to be informed of all the details of that one person that they visited with, whether or not they're credible? Don't you think a court, it goes without saying that a judge knows that he or she needs to balance and to consider the evidence? But when you're comparing evidence-based information, my goodness, look how much stuff is in the PSI that is not evidence-based, that nobody's challenging. Am I correct? There's lots of stuff out there?
Absolutely, yeah. It's full of information. But you know, if there was something reported that somebody said this and that person's not reliable, or didn't say that, or this thing didn't really happen, that what this person said, defendant did.
Doesn't that get back to Justice Katie's comment then? Then doesn't that put the onus on the defense counsel then to say, okay, regarding this PSI on this defendant, we challenge it?
I think it again goes back to whether it's factually inaccurate. That person didn't say that, or what they said about me was untrue. That would be on the defendant. But relying on these tests, the lack of transparency, especially in this case where there's nothing included about.
Well, that is a problem, but, Disraeli once said there's three kinds of lies: lies, damned lies, and statistics. And I think the problem is a bad statistical figure can have tremendous power and end up in a terrible, terrible place. I mean, it has a patina of science. It looks good. It's a number. We can reach on it. We can rely on it and go home for supper. But the problem can be that if it's junk in, it's going to be junk out. But I'm going back to kind of a theme I've had here. I don't know whether this is one of Disraeli's statistics. We don't know whether it's helpful or harmful at all. I mean, we know almost nothing other than this bulb has been hung on the tree. How do we end up getting to where you want to go on this record? I mean, you're kind of suggesting that, well, it may well be terrible, and maybe so, but it also might be of some assistance to the court.
I think that, again, it has to do with the court. You know, it would be of assistance to the court to understand how they're calculated, what, if they're valid, what that means to be valid even. What sort of, when somebody's labeled high risk, does that mean, what these studies are showing, that this means 60 to 70% chance of reoffending. And so to use that to decide whether to send somebody to prison or not, is that good enough? Is 60% good enough?
What specific remedy are you asking our court to impose? On remand, should the court be able to use this risk assessment with further information and a record developed, or do you want it banned altogether?
What we've requested is pretty much what Loomis has held, which is that there's certain uses of a risk assessment score that are improper, and that's deciding to incarcerate somebody, using it as the determinative factor that they cannot be supervised safely in the community, but that if there's certain on remand, that they can be used low risk, identifying low risk offenders and diverting them out, using them to decide appropriate probation conditions.
Can you have it both ways? Should a defendant who's deemed a low risk get that benefit, and the court can consider that in choosing probation over sentencing, and yet the same court, different defendant, could not send to prison if they're a high risk, same study? Can you have it both ways?
It's not that when somebody, first of all, the studies have shown that it's the reliability and the accuracy of identifying high risk offenders is much more problematic than identifying low-risk offenders. And when you identify a low-risk offender and divert them out, you don't have, it's not a due process, it's not a punishment, it's not the same, it's not enhancing punishment. But when you take it and somebody who's been identified as high risk, and then you enhance their punishment or punish them more harshly, that's where you have the due process problem. And courts all the time, again, we've always said in sentencing that you have to show that the district court relied on the improper factor before we're going to even talk about it. So just because something's in a PSI or mentioned somewhere, even the state makes the argument, some improper argument at sentencing, the district court doesn't mention it and it doesn't rely on it.
Isn't it reasonable to assume, when you talk about Loomis, what bothers me about Loomis is discretionary sentencing. A district court judge sitting in Iowa, they know that he or she does not have to decide if it's going to be 10 days or 10 years if it's a sentence, a Class C felony, for example. That has been removed from the consideration of an Iowa judge.
Mm-hmm.
So when you're talking about the Loomis judges, it probably had a much different, it probably had a profound effect on them to have an impact, to have a test or a tool that could actually determine the number of years. Knowing that Iowa judges aren't looking at it for that,
Mm-hmm.
does that change your argument at all?
Actually, I think if anything, it creates more concern, if I could finish, more concern with using it, because like you'll notice in the model penal code, they have tentatively, not wholeheartedly, but embraced using risk assessments to decide the appropriate sentence, even for higher risk, like definitely for low risk, but it can be considered for other risks. But they specifically justify that with the fact that they have determinate sentencing and that there's certain protections in place that aren't there in indeterminate. So I think actually that could cut against them being used in Iowa sentencing. For the reasons we've argued, we ask that Mr. Guise's sentence be vacated and remanded for resentencing. Thank you.
Ms. Nye, thank you as well. Ms. Hall, rebuttal.
I'd just like to mention Iowa Code Section 901B.1 subsection 4A, which directs the Department of Correctional Services to use a risk assessment evaluation in determining the proper sanctions and level of supervision for all persons placed on probation. Presumably this happens immediately after sentencing, if not before. And as I mentioned before, the Board of Parole has its own risk assessment program, and that was required under Section 904A.4 subsection 8. The Court of Appeals talked about Iowa Code Section 901.11 and read too much into that section. That allows for, that statute requires the use of a validated risk assessment in sentencing in determining the length of mandatory minimum terms for certain child endangerment, drug, and robbery offenses. We believe the Court of Appeals interpretation as that statute limiting the consideration of risk assessments at sentencing and other offenses is wrong, that it's discretionary, not prohibited. Assuming factors such as age, employment, and housing stability are factors under the Iowa Risk Revised, those are also facts that are listed in various sections of the PSI. They're already in there. Having an actuarial risk assessment as an extra piece of objective evidence-based information is more helpful to the judge than just reviewing all the categories of information in the PSI and coming up with his or her gut feeling as to what level of supervision might be appropriate. We believe that the notation intensive supervision alerted the court to consider what type of supervision, monitoring, and treatment programs might be available to this person in the community. It did not direct the court to order a specific sentence. And we would disagree with the defendant that the court in this case used the risk assessment information as a determining factor. I think if you'll read the court's statement of reasons as a whole, it shows it was just one factor of many. And I think that's all the extra points I have, unless the court has additional questions.
Ms. Hall, thank you.
Thank you.
Ms. Nye, thank you again. The case of State versus Guise is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.